All right, we're back at the REIQ with CEO Antonia Mercorella. G'day, Antonia.
Hey, Peter.
We got some new forms.
We do.
Exciting stuff.
We
Out
do.
with the old, in with the new, and they're good new forms.
They are.
We have that form 6, 7 and 8.
Correct.
To get rid of some of the other stuff that was driving us crazy.
Yeah.
Tell me about the form 6, 7. Let's start with the 6. Let's do it in order.
Let's start with the 6. That's the most important one. That's the appointment form. That's the one you need to get right to make sure you can get paid.
And lots of people used to get it wrong.
Yes, unfortunately.
And lots of people lost commissions around.
Yes.
And the new one's pretty streamlined. If you stuff this up, you've got to be pretty good to stuff it up, haven't you?
Yeah, you're probably got to make a concerted effort to get it wrong.
Okay, right. Tell me about the 6, because I think you said it replaces quite a few of the other...
So the Form 6 replaces 7 appointment forms.
Wow.
Yeah. So the idea behind the Form 6 is that it's a standardised appointment form. So any real estate agent providing any sort of service that's regulated under the Property Occupations Act, that's the form you have to use to be able to perform the service and get paid for it. So whether you're being engaged to sell a business or whether you're being engaged to manage a property or to sell a residential property or whatever the case might be, the Form 6 appointment form is what you need to use.
That's easy. So no confusion around that.
No
One
confusion.
Form, sign here. What's in the Form 6 these days that makes it simple for people?
So the Form 6 is down to 4 pages, but people need to understand that it really only meets the minimum statutory criteria. So that appointment form is really just about the bare basics, what the Act says you need to put in a form to be valid. So it's going to identify the parties, client and the agent, what's the thing that's being sold or the thing that's being managed or leased, and then it obviously goes on to really important things like commission, expenses, charges, etc., etc. And then there's a couple of other bits and pieces in there, whether it's being sold by auction, you need to put an auction date, things like that. So it's quite a basic form. And so because it's the form you use regardless of what you're actually being asked to do for your client, our view is that you wouldn't just want to complete the Form 6 and leave it at that.
Gotcha.
You really need to attach specific terms and conditions and schedules which are tailored to what you're being asked to do.
So it's the provision of property management services or the what specifically how property is going to be marketed if you choose to do that?
That's right. Yeah. So we had a property manager in our Brisbane Roadshow session earlier today, and she said, well, there's nothing in the Form 6 that deals with water calculations, or there's nothing in there that relates to there were a couple of other items that she mentioned, and we said no, there's not. And so it goes without saying that it would be extremely difficult, if not impossible, to manage a property on behalf of a client without having those things in order. So the REIQ has developed a set of 7 terms and conditions and schedules, and you pick those documents that match the service that you're being asked to provide.
So that will fit with that Form 6,
yeah.
whether it's residential sales or property management.
That's right. So there's residential sales, commercial sales and leases. We've also developed a brand new buyer's agency set of terms and conditions because we recognise that is becoming, that's been a gap in what we've provided up until now, and it's important to look after our buyer's agents.
Nice, well done. Okay, that's cool. So Form 6, pretty simple.
Yep.
The fee that's being charged, the service that's being delivered, the timeline that's there, the ability to reappoint someone for a period of time, depending whether it's the 90-day exclusive or whether it's property management. What else is in that 6? That's pretty much it, isn't it? It's pretty.
Yeah. So look,
simple.
the 6 has a few other little bits and pieces. As you mentioned, you need to specify in there, are you being engaged? Is it a single appointment or a continuing appointment? Nothing new there. And then, as you mentioned, you need to specify, if it's for a sale, you need to say, is it sole, exclusive or open? One little change, though, that people should be aware of is that at the moment, under the Property Agents and Motor Dealers Act, when you look at the appointment forms, it makes a reference to the fact that after the sole or exclusive has lapsed, it becomes automatically an open listing.
Okay.
And our reading of this new Act is that doesn't occur. So once that term ends, agents do need to be on their game with making sure that they go off to get that reappointment. So of course they can do that in the case of a residential property sole or exclusive appointment. They can do that no earlier than 14 days prior to the expiry.
Nice. That's nice. Okay, cool. All right, and Termination of agreements, how does that happen in the 6 these days?
So,
the new one as of December 1.
Yeah, there's a few changes in the area of termination rights. In a nutshell, the way that works is that if you've got a continuing appointment, you won't put an end date anymore post 1 December.
Okay.
However, either party can basically provide at least 30 days written notice, or if the parties mutually agree to a lesser date, then that's fine. So in other words, if you've got, let's say you've got a vacant property, and the client wants to terminate and you're happy to let them out immediately because there's not a lot of paperwork involved, you and the client can agree, let's call it quits immediately. But if you've got something that requires you, is something you've been managing on an ongoing basis and there's paperwork involved, you're probably going to need those 30 days to finish up what's required. So you probably wouldn't let them out any earlier than that, I would suggest.
Cool, okay, so it puts some simple guidelines around, or some simple rules around that, like guidelines.
Yeah.
Rules.
The other thing I should mention is when it comes to sole and exclusive, agents just need to be aware that even though for a residential sole or exclusive agency you have now got that extra 30 days, so it goes from the maximum of 60 up to the 90, you just need to be aware though that there is a provision in the new Act which says that a client is actually able to give you 30 days written termination, but not before 60 days has lapsed.
Okay, so they'll still get the full benefit.
So you'll still get, at minimum, you'll get 60 at minimum,
yep.
and potentially you'll get up to 90.
Yeah. Okay. Cool. Right. That's nice. Okay. So those that when you get a chance to see the 6, and I've had a look at that, I think it's a nice form. It's clean. It's crisp. It's tidy. You know, and as I said earlier, you've got to be good to stuff that one up. So I like it. Number 7, Form 7.
Form 7. Okay. Some important changes in this area.
Beneficial interest.
Beneficial
Always
interest.
been a curly one. Should I get a fee? Shouldn't I get a fee? What if mum buys it? What if my sister buys it? And I don't know how many questions there's all these scenarios. What's the new one?
So some really quite extraordinary changes in this area. So that Form 7 is what you need to fill out if there's a beneficial interest to the agent. So when we talk about beneficial interest, none of that's really changed. The way that that's defined in the Act remains the same. So if you take a look at the provision dealing with beneficial interest, what it looks like here and now in Property Agents and Motor Dealers Act, and what it looks like in the Property Occupations Act, they're virtually identical.
Okay.
So all of those normal relationships, so if you've got a personal relationship with the proposed buyer, it's your mum, it's your dad, it's your sister, etc., it's your spouse, if it's your child, and then also those special business relationships, or if perhaps a corporation is the proposed buyer and you're a member of that corporation. So all of those normal types of relationships that are covered, they still apply. Mm-hmm. But what's really important to note is that under the Property Agents and Motor Dealers Act, the only way you're allowed to have a beneficial interest transaction occur is by going and getting consent from your client for that transaction to proceed. So for instance, I'll go to my client, disclose the fact that my sister wants to buy the property, and before that transaction can proceed, I need to get my client's consent. But even if the transaction is able to proceed, you've not been able to get paid for your trouble. You've not been able to get commission. And so the main change is that using the Form 7 from 1 December, that's the form you take to your client to let your client know, hey,
this is mum.
This is mum, this is my sister, they want to buy your property. Are you okay with that? I'm disclosing that to you. And the form is very self-explanatory. It's a one-pager essentially. But most importantly, if your client consents and you're able to satisfy some requirements, which we'll get to in a moment, you can actually get paid.
And I can hear people cheering in the streets already. Because there's people, and look, it's a great discussion. Should I, shouldn't I? This puts clarity around, says you can if the client agrees.
That's
if
right.
the declaration's made.
That's right. So there is a declaration that the agent needs to be aware of that they make. So agents need to still be careful. This is great and it's to be celebrated, and it's pretty extraordinary stuff that we've been able to get this one over the line.
But we've got to get the paperwork right.
But you've got to get the paperwork right, and you've also got to take care, because the agent has to make a declaration that they've got the consent. That's an easy enough thing to do using the Form 7. But they also have to make sure that they've acted honestly and fairly, and that that client is still going to end up in just as good a position as they would have had that transaction occurred at arm's length.
Yep.
So agents need to be very careful. If you've got your sister buying the property and you're selling it to her at a song and you're taking advantage of the fact that you know you've got a distressed sale on your hands and that they're prepared to take a lowball offer, you need to be careful. So you really need to treat your sister in the same way that you would treat any other prospective purchaser.
So if you want to take the fee, make sure you get the paperwork right,
That's right.
and make sure you're not exposed to any no threat of anyone saying, but she got it cheap or he did a special deal.
Absolutely.
So there's a range of ways you can do that by way of CMAs or evaluations or third-party appraisals or
and look, at the end of the day, you know, if you're concerned about it, you can always encourage your client to go out and get some independent valuation advice. I mean, that's obviously the most ideal way to deal with it, because then there can be no dispute. They've gone off, sought some independent advice from an objective third party about what they should be taking for it. Now, that's, just to be clear, that's not a requirement.
No.
But if you're really
it's
concerned about that issue, that might be something you might want to encourage your client to do.
I think one of the things that you said this morning in the presentation, and it certainly sat well with me, and I'm sure with everyone else, is this the importance of having a paper trail of things that you do, because if the law comes looking, you know, they're going to start. So show me what you did, and if there's that paper trail that shows these are the things that I did to indemnify myself and to show that it was best practice, you can sleep pretty easy, can't you?
And look, I think as well, it's horses for courses, Pete, in the sense that if you've had a property sitting there for quite a long time and you've had a number of offers, and you've been able to establish what the market's prepared to pay, and then lo and behold, your sister suddenly goes, that property is perfect. Then you've kind of got a sense of what everyone else has been willing to pay for it. You've tested the market. If on day one your sister wants to buy that property, then let's be honest, you probably really want to be encouraging your client to get that independent valuation, because on day one, let's be honest, it looks a bit suspicious that you've got your sister in the sidelines immediately.
And look, you're absolutely, there's a range of things you could do there. You could either walk away, get retained by your sister, and not be retained by the seller. There's a whole range of things, I'm sure.
Yeah, look, it's and there's nothing compelling you to, you know, if you feel like, I don't want to sell it to my sister, I don't feel comfortable about it, I don't think you're compelled to sell it to your sister. But this gives you the ability to, because let's be honest, it's not so much with your personal relationships, but with the way that the world is so much smaller now, you might have someone who you've got some sort of a relationship with, who comes along and quite legitimately falls in love with the place and wants to buy it. It's just what they're looking for.
And under the old Act, or the current, or the pre-December 1 Act, there was no opportunity for a fee.
That's right.
December 1, there is.
Absolutely.
So, wonderful stuff. Now I know there was something you wanted to clarify this morning around the relationships go beyond family. It can be conjunctional agents.
That's right. So when we look at, so even though I said that the beneficial interest provisions are virtually identical under the old and the new Act, the one exception to that rule is that the definition of an associate has been expanded. So at the moment, an associate is really about those family members. I think it's the child, the spouse, the parent, sibling, etc., etc. The new, there's a new limb to what constitutes an associate, and that is a conjunctional agent. So if you and I've got the original listing, and then I come along and say, Pete, would you like to conjunct on this sale? And you say yes. And then a couple of months down the track, you say to me, you know what?
That's for me. This
house is actually for me. I want to buy it. You are an associate of mine under the Act, and that triggers that beneficial interest provision. And I, as the listing agent, would then, to be able to let you buy it, would need to go through that process of filling out the Form 7, getting my client's consent.
Nice. You know, so some changes. I just think that's nice. It's a simpler form and some clarity for the industry again to look back at itself again and say what happens in this circumstance. And so I like that. You know, again, there's been, as time goes by, people put all sorts of interpretations on what is or isn't a beneficial interest. And this again puts it back on the radar. Radar says this is what it is. So I like that.
Yeah.
Form 8.
Form 8. Look, the Form 8, I refer to that as the new 27C. It's the concept behind it is not really new. It's a disclosure of benefits to a buyer. the really neat thing about this particular form and about this new legislation is that finally we've been able to get rid of this ridiculous requirement to disclose to a buyer what our sellers are paying us.
Crazy.
So that whole notion of having to tell the buyer that the client's going to be paying me X
this much commission, this much GST, this is the advertising, this is the whole...
Which at the end of the day, there is no legitimate need for the buyer to know that. None whatsoever. So government listened to us on this and said, yeah, agree, that needs to go. So that form, the Form A, you need to complete it if you're aware. Well, two things. If you are referring that buyer to someone who you have some sort of a personal or commercial relationship with.
So a finance company, a mortgage broker, a lawyer, a carpet cleaner, a
go off to
building inspector.
Joe, the lawyer. He'll do the conveyancing for you, and then Joe gives you $50 for that referral. You'd need to disclose that. Or if you refer them to a finance broker, you get $100 for that referral. You'd need to disclose that. So that's not a new thing. That's always been the case under the Property Agents and Motor Dealers Act. The next type of disclosures that agents need to be aware of is where they know that any entity is getting a benefit from this transaction. Okay. So what I mean by that is we know that it's quite common now for accountants and I guess finance brokers, lawyers even potentially, to be perhaps promoting property investment to their clients, promoting particular properties. So if you know that there's an entity involved in that transaction who's been associated with the transaction and they're going to be getting a benefit, so that accountant, for instance, for promoting that property, they might have an arrangement in place which sees them get, I don't know, $1,000 for their trouble, let's say, and you're aware of it, you would actually need to disclose it.
Okay, so full disclosure on that.
Full disclosure on that. Now, it goes without saying, if the agent isn't aware of any of that, you can't disclose what you don't know, but certainly if you've got knowledge of any party getting some sort of a benefit in association with that transaction, then that's the place to disclose it.
Nice. So that's total transparency, though.
Yeah, absolutely.
I think we all saw so many bad things happen on in various parts of the state around marketeers and
Well, that's right. And look, I don't see that as being a bad thing. Some agents have expressed annoyance at the fact that they're required to do that, but at the end of the day, I actually think that it's beneficial to the real estate profession.
Oh, absolutely.
Because what we want is, we want to make sure that buyers are not relying on these people telling them to go off and buy something, and in some instances giving them advice to buy something at a highly inflated price, sometimes with an interstate buyer who doesn't necessarily understand the true value of the thing. We've seen it. And I've heard real estate agents who then get really frustrated because they've suddenly got these buyers who have purchased something at a rate that's too high, and now they're expecting a certain return on investment. And so then it's the Queensland real estate agents who's stuck with having to give them the bad news. And I think what it's about is letting the buyer know that if you've relied on the advice that this party's given you, you need to know that how independent is that advice. If they've received a benefit in connection with you buying it, maybe you need to think about, I'm not saying it's bad advice, but maybe that's going to let the buyer know that they need to give some thought as to whether they need to get some further advice or whether that advice was independent in the first place.
I think any of these things that lift the perception or lift the consumer's faith and confidence in us as an industry is a good thing.
Yeah.
So that we are in a world of transparency and people are entitled to receive the information. And for us to sort of hide behind that and say, well, it doesn't exist and let's not tell them is crazy. So to actually have that, if we know something, let's tell them. Let's tell them. I know you talked this morning, and it may be off track on the forms, the importance for us to declare to sellers anything they know about a property. So whether there's any issues with the property at all. I know you talked.
Yeah, look, this is probably the most controversial topic in real estate. What to disclose, when to know that you need to disclose, or what you can say, oh, well, I don't need to worry about disclosing that. That's up to a buyer to conduct their own due diligence. So I think that whole principle of buyer beware and feeling like you don't need to disclose anything because ultimately it's up to the buyer to go off and do their own research. I think we've seen quite a few instances where the law has shown that it's not quite as black and white as that anymore, and that there is an expectation that as a real estate agent, when you're acting on behalf of a seller, if you do have knowledge of material information, material facts that would, quite significantly impact on a buyer or even a prospective tenant for that matter, in terms of whether to buy or whether to rent that property. So look, I joked this morning that if I had $1 for every time I get asked, what do I disclose and what don't I disclose, I'd be a very wealthy woman. I don't necessarily have those answers, Pete. It's not as simple as that. But let's take the example of a stigmatised property. If you're involved in selling a property where there's been a gruesome murder, for instance, we know past experience has shown that, you should probably disclose that to a prospective buyer. That's something that they probably do need to know. Whereas that's versus something like you've become aware that maybe in the past the property's had an issue with, a burst pipe, for instance. That's the first thing that's popped into my head, and that's been fixed and that they've painted over the wall. Do you need to disclose that? No, I don't think you do. But in terms of then, what do you, what don't you have to disclose, there's no hard and fast rules. So my view of this is that you as an agent, what you don't want is you don't want to be the one who's in the firing line when it goes pear-shaped. And let's be honest, the agent usually is.
Well, I think there's a great life barometer that you could put on that, and it was referred to by someone recently, and it said, if you could answer the question and add the words "Your Honour" to the end, that's probably a really good barometer on what you should or shouldn't do. Are you prepared to stand in a witness box and say, "Yes, Your Honour," or "No, Your Honour, I felt I did the right thing, Your Honour"? Yeah. And look, I don't know whether that's good advice or bad advice, but I reckon it's not a bad life barometer to do things by.
Yeah, probably pretty good.
For me, that's sort of healthy. And I was with John Cunningham from the real estate agents from the South recently. And, John put it to me in saying, treat people the way you'd expect your mother, father, sister, brother, and daughter and son to be treated.
Exactly.
And I think that's pretty good advice.
Yeah, absolutely. And look, I think on that, it goes without saying as well, it's if you get asked about something, you should never lie. So, for instance, if a buyer comes along and says to you, has this property ever flooded? And it has, then Blind Freddie could tell you that the answer shouldn't be, no, it's never flooded. It should
and it's not even, I'm not sure.
Yeah. Look, I think, if you have knowledge that it's flooded, I think you should probably say, yes, look, I'm aware that it has flooded previously. There's no positive obligation on you to immediately disclose that, I don't think. But certainly if you get asked that question, you should answer it in an honest way. But, you can always qualify all of your responses with saying, look, my strong recommendation to you is that, if you have any concerns about the structural integrity of the building, or if you have concerns about pest infestation, please, if you'd like to put forward an offer, or if you'd like to go off and prior to putting in that offer, have some inspections conducted, let me talk to my vendor about that. I'm sure he or she would be open to
and
allowing
that's great advice.
that.
So potentially turn that question into a closing technique.
Yeah.
So we'd be happy to take that to the seller.
Yeah.
Based on you doing your research. Nice. Okay. So look, good things. So 6, 7, and 8, breath of fresh air, new forms. We shouldn't be threatened by those. We should get out and have a look at them.
You shouldn't be threatened by them. What I would encourage all agents to do is the forms 6, 7, and 8 are on the OFT website. You can't use them yet. You can't use them until the 1st of December, but there is no reason why you shouldn't print them out and get your head around them and sit there and practice them.
So jump into a sales meeting, let's do them.
Yeah, let's do them together. Let's go through this. And then if after going through that process you're scratching your head about how to complete it, give the REIQ a call.
Awesome. And they'll be on the RealWorks website as of December 1, available for people to use.
Yeah, absolutely. So we're launching our new RealWorks package tomorrow, and all of these new forms will be available from 1 December, and all of the new terms and conditions and schedules that accompany the Form 6 will also be available.
Fantastic. Antonia, I think you've done an outstanding job with this new Act. I know it's been hard work, and I know it's, we're all sitting behind the scenes doing all sorts of things and running our businesses, and you've been out there fighting like crazy to get this through. So for you, I guess you can now put your feet up and say, job done until the next time.
Oh, look, as I said earlier, we're really thrilled with the outcome. We got the vast majority of what we've asked for, and there've been a couple of compromises along the way, but overall I think mostly all for the good, really positive changes.
Everything that I'm seeing is good, and again, I said earlier, the 1,000 odd people there this morning nodding their heads saying, this is good, suggests it's good.
Great.
Good on you. Okay, thanks, Antonia.
Thanks, Peter.
Thanks for popping by again, folks.